best thing about being a member of CIArb is being part of a community of ADR practitioners where one gains access to professional development opportunities through seminars, workshops, and accreditation courses, as well as access to networking opportunities through conferences and social events.
We offer a range of courses which equip people with the knowledge and skills that they need to to avoid, manage, and resolve a dispute. Because we believe these are fundamentally important skills for people to learn.
The courses that I've taken through the Chartered Institute of Arbitrators have all been led by very senior practitioners. So also as a senior practitioner, it gives me an awful lot of opportunity to learn more, much more than sitting in a classroom and listening to someone speak.
Well, I'd recommend the CIArb training because it's very thorough. It's recognised as a gold standard, and so having the qualifications will help you in your career.
First of all, one of the benefits of being an associate at Chartered Institute of Arbitrators is an opportunity to visit events and conferences on highly interesting topics. You are not only engaged in discussions, but also you receive plenty of networking opportunities.
Not only was I able to attend events with leading practitioners and scholars in the field of international arbitration, but also CIArb allowed me to meet other students from all over the world with similar interests and thus develop further networking and professional skills.
Honorable Chief Justice Sir Brian Moree QC, Honorable Judges and other judicial officers of the Supreme Court of the Bahamas, Honorable Minister of Financial Services, Trade and Industry, and Immigration, Mr. Ellsworth Johnson, distinguished practitioners, arbitrators, and members of the Chartered Institute of Arbitrators, members of the Executive Committee of CIArb Bahamas, distinguished members of various professional bodies represented here this morning, distinguished guests, members of the press, welcome to our first webinar. My name is Doneth Cartwright and I will be your host for this morning's session. Protocol being established, I would like to invoke God's presence in our meeting. I pray that we will be inspired, informed, and enlightened as we navigate through unprecedented time and change. We pray for everyone's safety in this unprecedented period for our country and the world at large. I'm delighted to see so many people in this webinar this morning, and hopefully others will join us soon. This session will last for approximately 2 hours. So to ensure everyone's comfort and enjoyment, I'd like to remind you to keep your mics muted during the session, unless you're a presenter or you've been asked to unmute your mics. I hope you've had your morning coffee and you're sitting comfortably. Oh, well, no, don't be too comfortable now. 2020 has taken us out of our comfort zone and has forced us to look to the future, to start conversations about mediation, arbitration, negotiations, and how we infuse them into our culture, which is predominantly adversarial in nature. And what of those COVID-related conflicts that are on the horizon? And what of mediation as part of the pre-litigation process? Well, that conversation we will have this morning. We have an impressive lineup of speakers, Our Executive Chairman, Mr. Michael Digges, will lead us off, and then we will hear from our featured speaker, the Honorable Chief Justice. You'll also hear from the Minister, and then you'll have a panel discussion which will cover the legislative framework, career opportunities in ADR, building an ADR practice, maritime arbitration and mediation, which is a great opportunity for us here in the Bahamas, training opportunities, and the path to membership. You will be allowed to ask questions after each presentation, so please include your questions in the chat. There will be a recorded version of this webinar after the meeting, and it will be made available to you. I now have the distinct pleasure to invite the chairman of the executive committee, Mr. Michael Digges, who is an architect and an arbitrator, member of the CIArb Association, to bring welcome and opening remarks. Mr. Chairman.
Good morning. Thank you very much, Dawnette, for that warm welcome. And I appreciate the fact that you've established protocol. I think it's going to be important, and I thank you for mentioning the fact that, you know, this ADR space actually involves not only the legal profession, but all other professionals could actually participate. And that's where the greatest opportunity, I believe, lies for all of us. But I think it's important for me to at least recognize that this effort is not done alone. There's, you know, I work with a very impressive team, as you mentioned, of executives, and I'd like to use this opportunity to identify the executive committee along with the committee chairs. I think it's fitting that they be recognized for their efforts in what they do to execute the work that we are committed to perform. So I'll begin by identifying Rangan Johnson, who is the first vice chair. Shellen Ingram, who is the second vice chair and honorary secretary. She really is the one who gets us all going and make sure we're doing what we're supposed to be doing. Kenya Nottage is our third vice chair, and she's also our CIArb representative on the Bahamas Financial Services Board. And we thank her for, you know, accepting that appointment. Nicolette Gardner is our honorary treasurer, and we appreciate her efforts in making sure that our finances are in order. Dominique Nottage is the chair of the Young Arbitrators, and she's very, you know, all of us are very impressed by her accomplishments so far. I think she represents an example of what young professionals can be. Cherise Brown, who's the chair of education, and she's ably assisted by Reverend William Higgs. Yolande Roll, who's the chair of members committee. And of course, we have Carol Lashley, who's the chair of the legislative committee, and she is ably assisted by Calvin Cunningham and Justice Ruby Nottage. We also have Dawnette Cartwright, who's the chair of public relations, madam, who's the host for this morning's event. And so far, she's doing a stellar job. Cherise Cox Nottage is our immediate past chair. We also have assistants from Meta Hughes, John Michael Clark, Felicia Curry, and they also aid in whatever way they can in executing the work we have to do. I think it's, as the opening video was saying, the Chartered Institute of Arbitrators with headquarters in London, England, is the world's leading qualification and professional body for dispute resolution practitioners. There are over 16,000 members worldwide and offers courses in arbitration, construction adjudication, and mediation. CIArb Bahamas is the local chapter of the Chartered Institute of Arbitration, and we have about 55 financial members, and we intend to continue to grow our local membership. CIArb Bahamas offers education and training courses, as Dawnette indicated, and I am proud to announce that some of our members are actually approved CIArb faculty. This is the first time that this has ever happened. So that's a line, I think, a stellar move for all of us here in the Bahamas. CIArb London has formulated 3 strategic aims for 2021 to 2023. The first aim is to globally promote the constructive resolution of disputes. The second aim is to be a global and inclusive thought leader The third aim is to develop and support an inclusive global community of diverse dispute resolvers. So we here at CIArb Bahamas branch have established the following key goals for 2020-2021. The first is to work with other key stakeholders to ensure that we have the legislative framework for effective ADR. And this is led by Carol Lashley. And some of our key aims is to update the arbitration bill, establish a mediation and construction adjudication bill. A second key goal is to establish an arbitration center. This is led by Rangan Johnson and myself. Our key aim here is for the Bahamas to become a hub for ADR. The third key goal we have established is to create a Bahamas registry, and this is led by Rangan Johnson. And our aim is to have all qualified financial members to be on an official register. And a point of note, I think it's worth just making people aware, we've already been asked by the CJ Brian Moree to provide a list of CIArb trained mediators to be included on a list of CIArb appointed mediators. The fourth key goal that we have established is to promote and market CIArb Bahamas. And of course, this is ably led by Donette Cartwright. And this webinar is an example of what we intend to do. We really want to make ADR a household name for all of us here in this community. The fifth goal is just to facilitate the training and educational needs of our members and ADR professionals. And this is led by Sharice Brown. We really want to be the leader in courses in arbitration, construction adjudication, and mediation. The sixth goal we've established is to expand our membership base, and this is led by Yolande Roll. And our aim really is to double our membership over this period. The seventh goal is to focus on young arbitrators and students, and this is led by Theomonique Nottage. And we really want to establish pathways for future ADR professionals. And I think as a point of note, we have recently established a formal relationship with the Eugene Depute Law School to offer ADR training. And I'm sure Theomonique will talk more about this. As we navigate through the challenges of COVID-19 and the many disruptions it has created in how we previously functioned, we have come to realize that many of our previous norms and practices have to be re-examined. It is important to note that through our greatest challenges, we can find our greatest opportunities. Our theme espoused, as our theme espoused, we do need to examine the future of ADR and determine the new normal of how we will function in the future as ADR professionals. It has been estimated as a result of the disruptions due to COVID-19, the amount and the nature of disputes to be resolved will increase significantly. So the demand for ADR professionals will also increase. We should use this as an opportunity to prepare ourselves for the future demands of ADR. I look forward to your active participation in this webinar, and as we obtain further insights about ADR from the Chief Justice, Minister Johnson, and the various panelists. Thank you, and once again, we appreciate you joining us in this webinar, and enjoy.
Thank you, Mr. Chairman. That was well said. Now I'm going to invite Shellin, our Honorary Secretary, to introduce our minister. Shellin? If your mic is mute, you will have to unmute. Shellin?
Am I okay now?
Yes, we're hearing you now.
Yes. Good morning to each of you. It gives me great pleasure to introduce our guest speaker for today in the capacity as Minister of Financial Services. The Honorable Minister, a descendant of Dud's New Bight, Cat Island. He was elected to the House of Assembly on the 10th of May, 2017, and appointed by the Prime Minister to serve in the cabinet of the Bahamas as Minister of State and as Minister of Financial Affairs in the Office of the Attorney General. He held this post until the 30th of June 2019. On the 1st of July 2019, he assumed the post of Minister of Financial Services, Industry and Immigration. The minister is very involved in nation building, and he is the past president of the Bahamas Bar Association, former principal partner in the law firm of Johnson and Associates. He is also a member of the International Bar Association, Amnesty International, and the Rotary Club of Nassau Sunrise. He is also a member of St. Ambrose Anglican Church and is married to the former Miss Kathy Ann Cromarty. He is the proud father of 3 daughters, Christian, Megan, and Ariana. Please join me in welcoming the Honorable Ellsworth Johnson to the podium. Thank you.
You have to unmute your mic, Mr.
Thank you.
Okay, so thank you so much. You're still muted.
Okay, I'm on now?
Yes, you are.
Okay, thank you very much. Greetings all, and let me say what a delight it is to be here with you this morning. I was just receiving some technical advice from a phenomenal young lady who has brought so much to the ministry in the person of Miss Theomonique Nottage, and will mention her again in my presentation this morning. The Honorable Mr. Chief Justice Sir Brian Moree, QC, the Executive Committee of the Chartered Institute of Arbitration, and fellow panelists, participants, ladies and gentlemen. It is a pleasure to join you virtually today to discuss the future of alternate dispute resolution and the new normal. The Ministry of Financial Services, Trade and Industry and Immigration is responsible for entirely international commercial arbitration and to an extent other alternate dispute resolution processes, such as mediation and construction arbitration. As a part of this responsibility, the ministry is charged with the implementation and, where necessary, the revision of the legislative framework that supports ADR in the Bahamas, in addition to the promotion of ADR as a complement to financial services, international and domestic trade, and other industries or sectors. As a part of its mandate, the ministry is committed to establishing the Bahamas as a center for international commercial arbitration and other ADR processes. This initiative is important to the continued success of the Bahamas as a leading offshore financial center, as it will not only ensure that there are clear mechanisms to resolve disputes quickly outside of the scope of the courts, which have historically had a severe backlog, now compounded with the disruption in proceedings caused by the COVID-19 global pandemic, and the limited capacity within the courts can operate, but will also attract additional foreign direct investment. This has been a goal of the Bahamian government for nearly 2 decades. The pace has been slow, but our energy is renewed, and we are moving forward at an increased pace to accomplish this goal. In order to achieve this goal, the ministry has undertaken to revise the existing ADR legislative framework to ensure that the law reflects the best international and industry practice standards. Beyond this, the ministry, along with its industry partners, like the Chartered Institute of Arbitration, Bahamas branch, will advance ADR education and training of the legal profession and other local professionals who can participate in matters of ADR. We anticipate that this initiative to establish the Bahamas as a center for international commercial arbitration and other ADR processes will result in 1, the Bahamas becoming more attractive to international investors, 2, improving the Bahamas' position as a leading offshore financial center, and 3, the development of a new sub-industry that would ultimately positively affect trade and other commercial activities. We recognize that our renewed focus on advancing the Bahamas as a center for international commercial arbitration and other ADR processes have come at an interesting time in the world. For the first time in 100 years, we are experiencing a global pandemic, the likes of which have not been seen by other generations. Notwithstanding the challenges that COVID-19 has brought to the Bahamas, we firmly believe that with every challenge comes opportunity, and that this time is a unique opportunity to build on the work that is being done and bring our goals to fruition. In terms of the work to be done in relations to international commercial arbitration, international arbitration and domestic arbitration, international mediation and domestic mediation, and construction arbitration. Let me apologize. Now you know I'm home keeping house. Construction adjudication, the impact of COVID-19 on operations will be minimal as we have established an agile working environment which allows for staff to work remotely where necessary and to keenly observe COVID-19 safety protocols. Through platforms for video and audio conferencing like Zoom and WebEx, we have been able to effectively communicate as a group to discuss ideas and the plans to implement said ideas. As we continue to adjust the new normal, we do not anticipate there being much disruption in the continued work of the ministry to establish the Bahamas as a center for international commercial arbitration and other ADR processes, as we are able to work virtually in relations to the same. In fact, we have recently completed our strategic plan, which sets out in detail the steps we will be taking to establish the Bahamas as a preferred arbitral seat. The strategic plan prepared by the ministry's arbitration consultant is structured as a 2-year plan, 2020-2022. The 2-year strategic plan, 2020-2022, is set out below. It introduces the purpose of the strategic plan, for example, to establish the Bahamas as a leading center for international arbitration and alternative dispute resolution in the Americas. It continues with an historical background of the past consultancies, the work done in relation to the Permanent Court of Arbitration, the International Commercial Arbitration Survey, the International Commercial Arbitration Executive Council of the Bahamas, the training of technical staff, and the establishment of the Bahamas as an arbitration center. The strategic plan also sets out the rationale as to why the Bahamas, moving toward establishing itself as a center for international arbitration and ADR is a worthwhile endeavor. For instance, we have observed that international arbitration has become an important tool of economic development, which some have argued is directly connected to the increase of economic growth through foreign direct investment. For example, the combined value of international arbitrations which take place in London in any given year has been recorded as at $40 to $50 billion, significantly contributing to the income and legal and dispute resolution services providers, as well as the wider service economy in London. Moreover, this rationale is supported by data collected by surveys and case studies of other centers for international arbitration, which indicates that international arbitration and ADR is the preferred dispute mechanism by over 99% by law firms, in-house counsel, and other multinational entities. We know that ADR is the future. While the strategic plan considers the Bahamas' competitive advantage over other emerging jurisdictions in the Americas, it also outlines and details the many goals, objectives, and timelines that will achieve our overreaching goal and the strategic planners to achieve the same. To give you a quick overview, it is the intention of the ministry to, one, to establish the Bahamas as an UNCITRAL model law jurisdiction through the incorporation of the UNCITRAL model law by virtue of International Commercial Arbitration Bill 2020, to create government policy that addresses its relationship with the PCA and whether it would consider a host country agreement, to reintroduce the International Commercial Arbitration Executive Council of the Bahamas, rebrand it as the Alternate Dispute Resolution Council, and appoint its members, to organize education and training for international arbitration through partnership with industry stakeholders, to create government policy that addresses investment protection treaties and the possibility of investment protection legislation, and to market and promote the Bahamas for international arbitration through the assistance of BFSB and other industry stakeholders. To revise the Arbitration Act 2009 to ensure that it is consistent with the rules of court procedure and provide clarity on conduct of domestic arbitration, to encourage the use of domestic arbitration by local firms, private banks, and other local commercial entities, and to create a framework to support the establishment for a physical location for international arbitration and ADR in Freeport, Grand Bahama, international mediation, to create government policy on the Singapore Convention and ratify the said convention, to incorporate the Singapore Convention into domestic law by virtue of legislation, to draft and enact legislation that would support domestic arbitration, to draft and enact legislation that would support construction adjudication. One of the strategic partners that we will collaborate closely with in the execution of the strategic plan is CIArb. CIArb is an organization that has immense value and is of significant importance to the ministry. It represents a microcosm of the ADR community, and the technical skills of its members are a form of necessary support to the ministry as we revise the ADR legislative framework. For this reason, in addition to others, we accept CIArb's invitation to bring brief remarks on the occasion of its first webinar on the future of ADR and the new normal. As we move into the first quarter of 2021, we will strengthen our collaboration through additional work planned to establish the Bahamas as a center for international commercial arbitration and ADR, and look forward to the same. Having already given a brief overview of what we plan to establish in the coming months, I wanted to conclude my remarks by inviting each of you to attend the upcoming ADR symposium that will be held in January 2021 under the theme, Alternate Dispute Resolution and the Bahamas, Charting a New Course. We plan to release a save the date shortly with the registration information, and we look forward to working with CIArb and the strategic partners in continuing to create a strong future for ADR in the Bahamas. Ladies and gentlemen, and Mr. Chief Justice, it would be remiss of me if I did not make mention of some of the strategic persons in my ministry. And that is, I see that Ms. Deborah Watson, the Director of Financial Services, has joined us this morning. I know that if she has already not done so, that Ms. Raquel Pinder, the Director of Trade, will be joining us this morning, and no less a person, last but most certainly not least, the Director of Immigration, because we believe at the ministry that these three components are strategically important in terms of where we want to take alternative dispute resolution. It would be remiss of me also if I did not thank the Honorable Chief Justice for his kind advice, objective observations in our recent meeting courtesy call that we paid on him, and Miss Justice Nottage, Miss Carol Ashley. Now I'm going to get in problems by calling names, for your continued support of the ministry and your continued guidance of all the members of CIArb. Thank you very much, ladies and gentlemen. And it's a delight to be here with you today and throughout this presentation this morning. May God continue to bless you all, and most certainly the Commonwealth of the Bahamas.
Thank you so much, Minister Johnson. Collaboration, strategic partnership are some of the key words that jumped out of your message this morning. We thank you so much. It's a Saturday morning. We heard your dog and we want you to give him a little, rub his head a little for us. So many of us know what it is to have pets around us. Hopefully mine don't do that.
Not only pets, you have your wife, and she says that you must stay home and babysit.
You did a marvelous job, and we thank you so much, sir.
Okay, thank you.
The thunder of the person who moved the vote of thanks. So moving right along, I will now ask Mrs. Kelphine Cunningham to introduce our featured speaker, Honorable Chief Justice. Mrs. Cunningham, please unmute your mic.
Thank you. It gives me great pleasure to introduce to you the Honorable Sir Brian Moree, Chief Justice of the Commonwealth of the Bahamas. Sir Brian has had an illustrious career in the legal profession, covering over 40 years. He was admitted to the Bahamas Bar in February of 1979 and appointed a Queen's Counsel in 2009. He has acted as stipendiary and he's acted as stipendiary and circuit magistrate in 1983 and again in 1988. He has been an acting justice of the Supreme Court of the Commonwealth of the Bahamas in 1979 and again in 2015. He is a former member of the Bench Bar Committee, and he was the overseas member of the English Chancery Bar Association in 2010. He was the former chairman of the Commercial Law Committee, former co-chair of the Arbitration Tribunal, and former chairman of the Financial Services Consultative Forum in 2002. He was a former lecturer in civil procedure for the Bahamas Bar, a member of the Judiciary Salaries Review Commission in 2000. He was also a member of the Judicial and Legal Services Commission, a Constitutional Commission in 2015, a former director of the Bahamas Financial Services Board. He was a former co-chair of the Bahamas Trade Commission. He was also a former chairman of the board of directors of the Business License Review Board for New Providence. He was a former chairman of the Public Service Commission, which is also a constitutional commission. He was named in 2007 as the Executive of the Year by the Bahamas Financial Services Board in recognition of his contribution to the financial services industry in the Bahamas. He was appointed Chief Justice of the Commonwealth of the Bahamas on the 12th of June, 2019. Ladies and gentlemen, Sir Brian has brought a paradigm shift in the judiciary. Never in the history of the Bahamas judiciary has a Chief Justice made himself so readily available to the bar, to the press, and to the public. He has been on talk radio shows informing the public of where the judiciary is, where the judiciary intends to go. He has answered questions of the public and of the press, and he's brought clarification to any misunderstanding. Sir Brian has set the pace in the judiciary for the next century. Ladies and gentlemen, Sir Brian Moree.
Thank you very much, Mrs. Cunningham, for that very generous and those very kind remarks. I would like to share my screen if I can. Hopefully you can see my screen.
Yes.
We can. Yes, we can.
Very good. Minister, other distinguished guests and panelists, I respectfully adopt the protocol that has been established, and I would wish to thank the organizers of this event for inviting me to briefly address you. I'm hoping to share with you this morning, for the short time that's been allocated to me, a few thoughts about the subject which I have been given. ADR, the court, and the new CPR, which we are going to introduce in the beginning of next year. I've tried to make this a very practical presentation, and hopefully we will have some time for questions and answers and for a discussion, because there are a number of matters which I will identify, which I would actually welcome your input on as we move forward. The first thing I'd like to say is that an ADR regime, which is effective and which is available, is a necessary adjunct to any modern court structure. The reason for this is very simple, and I have shared this with some of you before. There is no court system in the world which is able to take to trial every case which is filed. It is physically impossible. It doesn't matter which country you're in, how large the country is, what resources you have. It is simply not a viable option for any court system to take every case to trial. And consequently, it is necessary as an adjunct to the system in certain cases, and other times as an integral part of the court system, to provide alternative means of resolving disputes, which will pick off a large volume of cases before they go to trial, thereby leaving the court system to deal with the remaining number of cases. In many jurisdictions, not the Bahamas, I might add, but in many jurisdictions, the percentage of cases which are commenced, which actually go to trial, vary anywhere from 20 to 40% on the data which I have been given and which is available to me. In the Bahamas, that number is much, much higher. And that results in cases floundering in the system all too often, and it does, of course, result in a backlog. Now, I might add that backlogs are a perennial problem for court systems all over the world. There is no court system that I'm aware of which doesn't have a backlog. It's just a question of the degree of that backlog. And in the Bahamas, I have implemented a backlog reduction strategy, which prior to Dorian and then COVID-19 was intending to reduce our backlog to an acceptable level within a period of about 36 months. I've had to seriously reevaluate the backlog reduction strategy in view of particularly the COVID-19 pandemic, because of the state of emergency which has existed since March of this year. So the first point I wish to suggest to all of you is that the work which you are doing is very important, not only in the context of the commercial life of the country, not only in the context of our economy, but it is extremely important and must be an integral part of the administration of justice in the court system, which is why I'm very grateful to many of the persons who are attending this webinar today for their assistance and for their contributions in our dialogue as we're trying to develop together an effective strategy to incorporate ADR into our court system. Now, I want to share with you a couple of the models that we have been looking at. How do you incorporate an ADR regime into our new civil procedure rules? And I'll be referring to those as the CPR. More generally put, how do you incorporate ADR into your court system? Well, here are a couple of models that we're looking at. First, some courts establish the ADR program within the court structure itself, and then have their court staff provide the ADR services. To some extent, some of the courts in the Caribbean have done this, and some of the courts in the United States have done this. I do not think that this is a viable option for the Bahamas because of our limited resources. But nevertheless, it is a model which we are looking at. And by the way, I would be interested in your views on these models when we have a chance to have a discussion. Secondly, the model is where the courts develop and maintain a roster of neutrals, and that's simply a reference to mediators and adjudicators. The courts develop and maintain a roster of neutrals from which neutrals are appointed by the court. And the third model is where the ADR program is outside the court system, and the courts contract with an outside entity to administer the ADR program and provide services on the court's behalf. This is literally almost a subcontracting out of the ADR program to a third party. I think that options 2 and 3 are viable for us. I have a view on which of those is probably the best model for the Bahamas, but I won't share it with you at the moment because I'd like to hear your views, and maybe we'll come back to that. I borrowed these diagrams from some material which I have, so I want to give proper attribution. But this is just in a diagram form what we're looking at. Who provides the ADR services to the court system? Well, it's either the court staff itself, which is internal. It's either through some sort of roster, which is prepared by the court, or you subcontract it out to a third-party vendor or service provider. The second point is the decision that we have to make in trying to incorporate the ADR regime into our court system is the basis upon which you're going to run it. The first option is participation in the program. Is it mandatory or voluntary? This actually has some legal implications. Court systems around the world have a different approach to it. We have to decide in the Bahamas, not only the first question that I canvassed with you, the model that we're going to use, but we've got to decide whether within the context of the CPR, it's going to be mandatory or voluntary. Now, if it is voluntary, it can be strengthened through what is referred to as a cost-sharing regime, which is incorporated into the court rules, which basically involves the concept of giving the court jurisdiction to impose cost sanctions on parties who do not participate in what would be a voluntary program. So you might suggest that that's not then exactly voluntary, and you would have a point. But it is an approach which many courts have taken, and consequently, if you choose to refuse to participate in the ADR program, that might have cost implications for you, depending upon the outcome of the case. So voluntary or mandatory, that's one issue. The second option is Do we have an opt-out or an opt-in plan with regard to our ADR module? In an opt-out program, everyone participates unless they opt out. So in other words, participation in the program is the default. And by default, you participate in it if you are a litigant. And if you want to opt out, you have to actually do that. Alternatively, only the parties participating in an opt-in program are those who actually take a specific action to indicate that they wish to participate. So that's the converse of the opt-out. Opt-out is you're in unless you take some steps to opt out. And opt-in is you're actually out of the system unless you take some steps to opt in. The third issue that we have to address in putting together the module, the AR module, is who's going to pay for it? How is it going to be funded? One option is for the courts to provide the ADR services itself. And in that model, it really is the court staff that provides those services. And so those staff are obviously paid for by the court. As I've indicated, I don't think, given our limited resources, that is a realistic option for the Bahamas at the moment. Second option, the courts maintain a roster of neutrals. And again, neutrals are mediators and adjudicators and facilitators, who the court or the parties select, and the court pays the neutrals in any given case up to a certain amount. The third option is where the courts maintain the rosters, where the parties pay the neutrals, or the neutrals volunteer, or some combination of those two. And the fourth option is where the courts contract with other entities to maintain rosters of mediators. In this option, mediators are paid by the court or by the parties, or they may be volunteers. And a slight permutation on that model is where mediators sometimes volunteer an initial block of time, and then if the parties wish the process to continue, they have to come to an arrangement with the mediator or the facilitator in that particular case. I must say that of all the issues that I have been dealing with in trying to establish and implement the ADR module, is the question of cost and funding. Given the very limited funding that we have available to us, this has been a vexing problem. And I would invite your comments on this when we have a chance to do a little bit of Q&A. That's just a diagram of what we talked about in terms of who's going to pay for it. It's either the court, it's either the parties, or it's neutrals volunteering their time, or in fact some combination of those three options. The fourth point that we have to decide in terms of implementing the ADR module is whether it's going to be binding or non-binding. Now, with regard to mediation, most of the time, mediation is not binding unless it is expressly agreed that it would be binding. But a mediation agreement in law does really have the effect of a contract if it's properly done. And so there is an option that if there is a mediation procedure which results in a successful resolution, part of that mediation procedure is for the mediator to at least produce a term sheet which sets out the basic terms of the agreement, which the parties then and there sign, if they're represented, of course, with the advice of their lawyers. That's very important because, you know, there's a lot of buyer's remorse in these mediation results. In other words, you are there oftentimes for many hours. If you have a skillful and an effective mediator, you come to the end of the process. You've been brought together by the facilitator. You end up agreeing something. You all go home, and then you try to document the arrangement 2 days later, and you find that people have a different view of the matter. They have second thoughts. So any experienced mediator is going to get the parties to sign a term sheet. And so in that sense, it can be made binding. Or there is something in our procedure called a Tomlin order, which the lawyers would be familiar with. And that's simply an order where the court blesses the settlement or the agreement and gives the parties liberty to apply with particular reference to enforcement, which does in fact put some real teeth behind the agreement. So that's the fourth matter. And again, this is just a diagram showing those options. Now, I have worked my way through those four options, and I have developed a view, but I would, as I say, I would welcome a dialogue on this if we have time later today to get your input on it. Now, just very briefly, let's look at arbitration first as one of the ADR processes. Of course, the purpose of arbitration in a sense is to avoid the courts. So this is not so much having a case in the system and trying to resolve it before it goes to trial. Arbitration is a preemptive measure whereby the case doesn't get started in the court in the first place. Now, the impact upon the work of the court is, of course, equally as important as mediation, because rather than picking off the case before it goes to trial, arbitration picks off the case before it even gets to the court. And that's a very important point in terms of the administration of the court in order to try and minimize the volume of cases that we have to deal with. So the arbitration regime, and I'm speaking primarily here of domestic litigation, but also in terms of cross-border and international litigation. To the extent that the parties have agreed to arbitrate, that case is not going to get into our court system. And that's a good thing, because the fewer cases that come into our court system, the better, bearing in mind that overall, there is a constitutional mandate to provide open access to justice for all parties. But this is why promoting arbitration as an effective means of resolution in family disputes, domestically, in commercial disputes, both domestically and internationally, it is, I think, legitimately an issue for the courts. Because first of all, there is a level of involvement that the courts have in oversight of arbitrations to ensure that they're fair and they're proper, while at the same time trying to respect the autonomy of the parties to select arbitration as their preferred mode of disposition. Arbitration's been around forever. I just thought I would tangentially tell you that it goes all the way back to Plato and the Greeks, if you can believe that. We got a lot of our justice from the Greeks. Arbitration existed way back then. And certainly during the last 50 years, its utilization has substantially increased, both internationally and domestically. And now, of course, it's a preferred way of resolving many disputes. Initially, the courts were not very friendly to arbitration, but fortunately, going back to the 19th century, in a case actually which was decided in 1856, Lord Campbell criticized the original hostility towards arbitration, and he started a new judicial view on arbitration, where he said that the era when courts of law seemed to consider a reference to arbitration to be wrong had passed away. That was a watershed moment in the development and in the coexistence of arbitration and the court system as a means of resolving disputes. In England, the ADR module was first introduced in a formal sense in their civil procedure rules in 1998. So you can see that we are a little bit late to the game. Some of the advantages of arbitration, and I know that all of you would be very familiar with this, so I'll do this very quickly. Enforceability through the New York Convention now, it's easier, in many jurisdictions, it's easier to enforce an arbitration award than a judgment, unless, of course, there is some sort of reciprocal enforcement of judges' treaty between the jurisdictions. Secondly, it's a neutral forum for dispute resolution. Many times the parties don't want the national courts of either of the parties to resolve the dispute, because there is this perception that there's a sort of home court advantage. Arbitration allows you to pick a neutral jurisdiction. Procedural flexibility, it's far less complicated and usually far more expeditious than most court procedures, and the parties themselves can actually frame the procedures together with the arbitrator or the panel. Fourthly, if you are dealing in a very technical area, as good as judges are, they are not experts in every area. With an arbitration, you can select experts who specialize in the area of the dispute. And then fifthly, I refer to party autonomy, where the parties can agree the dispute resolution themselves, and they're very invested in it. So arbitration as a subject is a matter which I continue to be very interested in as the Chief Justice, because frankly, it helps and has a significant impact on the volume of the work of the courts. Moving now to mediation, which is perhaps the most pervasive form of ADR that we have in the court system. Just a quick rudimentary definition. A structured, effective, and practical mediation component must be incorporated into our civil procedure rules to provide an alternative dispute resolution mechanism to avoid the need to take all cases to trial. I've made that point. Just giving you a few quotes. What does mediation do? It moves parties away from focusing on their rights and liabilities and towards considering their needs and interests. Now, I just want to pause there for a few seconds, because that is actually a very important statement. It's one that was made some time ago by an experienced mediator. And let me give it to you again. I want you to think about this for a moment. In the context of a legal case, there is really a tendency for the parties to focus upon what are my legal rights? And on the other side, what am I legally liable for? I mean, those are the parameters on both sides. And then you start focusing on my legal rights. I want my legal rights. I want to enforce my legal rights. Or what are my liabilities? I'm really focusing on how do I mitigate my legal liabilities. Frankly, that type of disposition is not very conducive to a settlement, because parties become all very focused, as I say, on rights and liabilities as opposed to compromise. What does the mediation do? A skillful mediator gently moves the parties away from your rights and liabilities. That's really not what you should be focusing on in the mediation. What you should be focusing on in terms of a settlement are what are my needs? In other words, what do I need to make this work? Now, what I may need may be a lot less than what my rights are. And that's an important point. I may not need to enforce the full extent of my rights. But as long as I'm fighting in the context of the court system, that's my focus. If I move away from that and I said, all right, in order to make this work, this is what I need. And then, of course, you combine that with really, what are my interests here? Put the two together, right? My needs and my interests. Now I have the basis for some common ground, because frankly, there is compromise involved in those matters, unlike if I'm trying to enforce the letter of my rights. So I think that's very important. Another quote, if litigation is war, then mediation is diplomacy. I just thought that was a rather succinct way of putting it. And then, of course, in mediation, the enforcement and resolution does actually tend to be sometimes more effective because the parties own the solution. It's not being imposed upon them. So while it is usually by definition a compromise, so nobody's gotten all of what they've wanted, nevertheless, it hasn't been imposed upon them by a third party. And so the level of enforcement is often much higher without further litigation than in the context of a judgment, where in many cases in a lawsuit, getting your judgment is only the first step. You now have to go to enforce it, and that can cost a lot of money and take a lot of time. Just a few other thoughts about the mediation process. And again, these are a collection of quotes that I've come across. No requirement to reach a fair or just or equal agreement. Only one which is acceptable to the conflicting parties. Now, again, that actually is quite profound. A court is all about reaching a fair or just resolution of the dispute according to the law. That's what a court is charged to do. In a mediation, those are abstract concepts. Anything is fair if the parties agree to it and if they accept it. And so you can move again from this rather structured approach to fair and just and equity to what actually is acceptable. And that may give you many more options to resolve the dispute. In mediation, the resolution is through consensus and not coercion. It's cheaper, it's faster, it's informal, it's confidential, it's less adversarial and divisive. And you have many more creative options in order to frame a resolution than you would have in the context of a lawsuit. Now, let me move, in the interest of time, let me move now to the new proposed civil procedure rules, because I was asked to just focus on that briefly. What I'm giving you now is not the existing rules. These are the new rules, which will be put out for public consultation in before the end of January. CPR 25.1 is the gateway for mediation into the court process. That rule will read, the court must further the overriding objective by actively managing cases. Now, the overriding objective is a principle upon which the entire CPR is based. If we look at subparagraphs H and I, you'll see that H says that the court is to encourage the parties to cooperate with each other in the conduct of proceedings. Those are rather neutral words, but they are very important in the context of the jurisprudence, which is developed on the CPR model. And then I reads, the court is to encourage the parties to use any appropriate form of dispute resolution, including in particular mediation, if the court considers it appropriate and facilitating the use of such procedures. That's the substantive gateway. Under this subparagraph, the court is authorized or has the jurisdiction to actually adopt mediation and to facilitate the use of the procedure. Now, what happens is, under this rule, I would issue practice directions and guidance notes, which would flesh out the mediation procedure and the module together with all of the steps involved in it. Another rule which will be relevant in the new CPR is 26.1. This rule will read, the list of powers in this rule is in addition to any powers given to the court by any other rule, practice, directions, or enactment. And then 2, except where these rules provide otherwise, the court may, and then this is subparagraph V, take any other step or give any other direction or make any other order for the purpose of managing the case and furthering the overriding objective, including hearing an early neutral evaluation with the aim of helping the parties settle the case. Now, I don't have time to go into this, but again, the case law on this particular provision supports a very wide and liberal interpretation of this rule, which gives the judge an opening to all of the ADR tools which exist in order to try to further the overriding objective and to resolve the matter. Early neutral evaluation is a relatively new concept, and we'll see if we have time to deal with that. But the combination of 25.1 and 26.1 will provide, as vanilla as they may look to you on the screen, they provide the massive gateway into the world of ADR in the context of the civil procedure rules. And using this platform, practice directions and guidance notes will be issued in order to develop a full-fledged ADR regime which will be incorporated into our civil procedure. Now, I'll go through this very quickly. This is a view of how the mediation module might look going forward, although I hasten to say that it is subject to further consultation. And you all have certainly an opportunity to give your input on this, and I will be consulting widely with the ADR community. But at the moment, we're looking at something like this. There's going to be a court-connected mediation regime, and that simply means that mediation can exist, of course, outside of court, and we leave the parties to deal with those matters. But we're going to be dealing with court-connected mediation. The whole process in the courts will be managed by a court-connected mediation committee. The court-connected mediators must be certified by the Bahamas Judicial Education Institute and placed on the roster of mediators. That is a process to give the court quality control over the College of Mediators, or the roster of mediators that we will be using. I got in square brackets who appoints the mediators. Are they appointed by the committee, the CCMC, or are they appointed in some other way? That's an open issue. We can discuss that. The recommendations for the appointment of the mediators to be placed on the roster must be made to the Chief Justice. So ultimately, the Chief Justice will sign off on it. But that will be based upon the recommendations that come from the relevant parties. Thirdly, the committee will monitor compliance by the mediators with a code of ethics, which will be developed for all mediators involved in court-connected mediation. And this CCMC will also deal with any complaints about the process or about mediators' partiality, unfairness. The committee will deal with all of those in accordance with established protocols. And this committee will monitor the overall effectiveness of the process and make recommendations from time to time. I will establish a mediation unit within the court structure, and we will have a number of mediation coordinators who will be responsible for the administrative oversight of mediations as they go on. Moving rather quickly, when a case is filed, the claimant, the plaintiff, if they wish to submit to an immediate mediation process, there will be a form which the parties will fill out. The same for the defense. And if both parties wish to be involved in a mediation session right away, the court will make a referral order. That'll go before the registrar. Now, the consent of the parties, it comes back to whether there's going to be some element of coercion here, or compulsion or not. Whether or not we will need both parties to agree is a matter which we can talk about. That's an open issue at the moment. I have my views on that, but we can see where that goes. But the mediation process will start with the parties indicating their willingness to participate in it. That'll lead to a referral order by the registrar. The registrar or a judge can themselves make a referral order at any stage in the proceedings, and that'll either be with or without the consent, depending upon what we decide there. Once the referral order is made, the parties will not be allowed to opt out of it unless they get an order from the judge or registrar based upon good grounds. Moving rather quickly, the joint responsibility of the parties, will they select a mediator or will we do it another way? The first mediation session would be a maximum of 3 hours. After the 3-hour session, the parties with the mediator will decide whether there's a basis to go on, and if so, they can continue it, or if it looks like it's a waste of time, it's not going to work, then the process would end at that point. After holding a mediation session, the mediator must file with the court office either a certificate of non-compliance, which means that one or both parties didn't comply, and that could carry cost implications, or secondly, a notice of outcome of mediation, which indicates that the parties have not fully settled the matter, but they participated in it in good faith. Obviously, if the case was resolved, then that would be communicated to the court. I don't think I have time to deal with the early neutral evaluation that I was going to address. I'll leave that for the moment, and if you're interested in it, we can come back in the Q&A. For the lawyers involved, I would just mention this case of Lomax and Lomax. It's a very interesting case, and it has opened up a new pathway for this procedure called early neutral evaluation, which has expanded the discretion of the court to embrace alternative dispute resolutions. So I would, if you're interested, I would recommend that you read that judgment. So on that basis, I will conclude by saying this. We are well advanced into developing our mediation module, which will be introduced through the CPR. We certainly want to engage in dialogue. There are the general macro points, which I've tried to briefly cover. And then, of course, there are the micro points in terms of how is this procedure going to work. And I tried to highlight some of those main points. In terms of arbitration generally, you will find that the courts in the Bahamas are arbitration friendly. We are training our courts, our judges, on international arbitration. And I have established a special commercial division, which will only involve judges who have experience and have gone through certain training. And a subdivision within that commercial division is going to be arbitration, international arbitration. So all cases involving the enforcement of arbitral awards, the oversight of arbitration proceedings, applications to the court with regard to party autonomy issues, they will all go to this specialized subdivision, which will start off with 2 judges who have experience, and as I say, we'll be training our judicial officers in these areas. So on that basis, thank you very much. I welcome the opportunity to engage in this dialogue, and I look forward to hearing the other speakers as the morning progresses.
Thank you so much, Honorable CJ. There are some questions in the chat, and I'll just read the first one. Define court staff in reference to the ADR.
Well, that is simply a reference to members of staff who would be assigned to the mediation unit. I mean, obviously we haven't identified them yet, but the point I was trying to make there is that there's no outside funding involved in that model, because the persons who will be providing the administrative support would be staff members. Now, I don't mean to suggest that the mediators would be court staff. So I should have made that point perhaps a little more clear. This is the administrative support for the mediation module. As opposed to doing that on the outside, we do it on the inside. And so we have our own court staff members. But I certainly do not anticipate that staff members would actually be mediators or facilitators.
Thank you. And the other question is, what is the timeline between applying for mediation and the mediation process beginning?
Well, I can tell you what I would like it to be. We're going to see how it all develops. The way in which we intend that to happen is a maximum of 21 days. Now, that assumes that we're up and running. That assumes that we have an adequate number of certified mediators. And that of course assumes that we have our infrastructure in place. But remember, mediation can happen either immediately after the case is commenced or the defense is filed. And that needs to happen quickly unless mediation is actually going to slow down the case as opposed to accelerate it. So that would be an unintended consequence. So the upfront mediation has to take place quickly. I'm looking at 21 days. Thereafter, a mediation can happen at any stage of the proceedings. But again, while the mediation proceeding is pending, the case is effectively stayed. And so that's why it's important that the process, one, happens quickly when it is requested and when the parties agree to it, and two, does not drag out, for months and months. Because while that mediation process is extant, that case is basically stayed. And remember, we're not introducing mediation to slow down cases. We're introducing mediation to accelerate the resolution of cases. So the element of the timeline in either scenario, upfront or at some stage during the proceedings, must be tightly controlled in order to avoid further delays, which would defeat our purpose here.
Another question, thank you so much, CJ. What happens in CPR where the claimant wants ADR and the defendant refuses?
Well, that depends on what regime you have implemented. In other words, is it a voluntary one, or does the court have the power to impose it? And that's one of the questions that I posed in my presentation. If you go with a voluntary regime, then both parties, or indeed sometimes it's more than two, all parties would have to agree to it. That does marginalize the utility of the mediation module. So I must say that whether we can accomplish it or not is an open issue. But I would prefer to have a regime where the court would have the power to at least, let me use a careful word, to at least encourage strongly the participation in mediation. Otherwise, parties themselves can frustrate the entire process by simply saying no. So that's an issue we're going to look at, but we hope that based upon the jurisprudence which has been developing, that the courts will have some level of jurisdiction to encourage participation, even if it's through what I refer to as the cost-sharing regime. In other words, if you may not be able to compel somebody to participate in a mediation process. That's a legal issue, and I don't want to express a view on it. But certainly what you can do as a court system is to say, when the case is over, if the non-cooperative party has won the case, the court has a wide discretion on costs. And the authorities are very clear that at that point, the court could take into consideration the non-cooperation of that party in the mediation process, even if they have won. And that is a way of reinforcing the mediation module, even if it's not compulsory.
Thank you so much. I see a comment. Once implemented, mediation will greatly contribute to the efficiency in civil matters. And there's also, not sure if it's a question or a comment, greetings. Should perhaps for various reasons it not be feasible that a mediation form is submitted, the other party might submit form either to agree or disagree with the reasons. I think that may have been a comment.
Well, I certainly agree with the initial comment. The introduction of an effective mediation module, I think, will greatly enhance the disposition cycle of cases in two ways. It'll obviously, cases which are successfully mediated will be resolved much, much more quickly, and certainly for much less money. It'll also have an impact on those cases which are still in the system, because every time you resolve a case through mediation, that's one more case the court doesn't have to hear. So the resources can be directed into the other cases, which is why I'm convinced that we must have a mediation module in our new CPR.
Yes, thank you. And we have a question from one of our participants who is all the way from Portugal. And he would like to hear your views on the unnecessary appeal of arbitration decisions to state tribunals or arbitral tribunals.
Well, this I think was addressed in my generic comment that the courts have an arbitration-friendly approach to arbitration. The role of the court in an arbitration is the subject of jurisprudence, which is well developed. Arbitrations, of course, are the subject of contract. No arbitrator has any power statutorily. There's no inherent power. It all comes from the contract, which is the arbitration clause that has triggered the arbitration. So in many instances, the actual clause itself or the arbitration agreement might address the issue of appeals. But otherwise, I think I can best answer the question this way. An appeal of an arbitral award under the jurisprudence is the exception rather than the rule. Certainly, if there's been a lack of due process or there's been a want of jurisdiction or something of that nature, there is a right to appeal. That oversight is there simply to ensure the integrity of the arbitration process. But in terms of appealing because you think the arbitrators got it wrong, or you don't disagree with them, or they've made findings of fact which you disagree with, that is very difficult. And that's the difference between courts around the world developing what is referred to as an arbitration-friendly approach. So you're not going to get two bites of the cherry. You can't jump out of an arbitral award just because you don't like it. It has to address the fundamental fairness of the process if you're going to have any chance of appealing.
Yes, and there's a comment, it seems to me that the court-controlled mediation would engender the confidence of the public in the judiciary. And on that note, we want to say thank you, CG, but I will invite Yolande, one of our ExCom member, to move the vote of thanks to you and to the minister. Yolande?
Good morning. On behalf of the Chartered Institute of Arbitration Bahamas chapter, I would like to express our sincere appreciation and thanks to both the Honorable Ellsworth Johnson and the Honorable Chief Justice, Sir Brian Moree, QC, for taking time out of your Saturday morning. We know that time is an expensive commodity, and we are so appreciative that you consented to be with us this morning. We agree with you, Chief Justice, that ADR is a necessary adjunct to any court structure. And of course, we agree with you that the work ADR professionals do is very important and an integral part of the justice system. We look forward to further collaboration that will take place as we seek to incorporate ADR into the civil procedure rules. In addition to us having an already arbitration-friendly regime, we are excited about the possibilities that mediation will bring to the court system. After listening to your remarks and what is proposed for the new CPR, we know that the future is bright for ADR professionals, inclusive of arbitration, mediation, and early neutral evaluation, and for those who choose to practice in this area. Honorable Ellsworth Johnson, we are so grateful that the government has taken a keen interest in promoting international arbitration and the Bahamas as an international arbitration center or an arbitration center. We are so excited about this initiative, and we look forward to collaborating with the government and all those who seek to promote this initiative in the coming days. So once again, we thank you for joining us. I'm sure I speak on behalf of all the members of CIArb Bahamas chapter and those present that we have enjoyed and learned so much from both your presentations. Thank you again.
Thank you very much.
Thank you, Yolando. I just want to pay respect to Mrs. Bertha Cooper Russell. I understand, I think I saw her join the webinar. Welcome, she is our founding chairman. Welcome, Mrs. Cooper Russell. And now you will notice that I have the Junkanoo background as my virtual screen. I know it's Junkanoo season. I wanted to do some Junkanoo vibe, but we had a disagreement at the exec committee level, whether it would be sounds of the Valley Boys or it would be Saxon. And, you know, I didn't want to get myself in trouble, so we'll stick with the virtual background for now. If you'd like a copy of it, let me know and we'll email that to you so that you can save it to your computer. So welcome everyone who joined us late. And we're going to move into another segment of this program, and it will be a mini panel discussion. Our moderator this morning will be Mrs. Rengen Johnson. She's an attorney at law and the former Northern Region Deputy Chief Magistrate and Family Island Circuit Justice. She's a member of the Chartered Institute of Arbitrators since 2011 and is presently the first vice chair of CIArb Bahamas branch. And so I will hand over the rest of the program to Mrs. Rengen Johnson. Please unmute your mic if you haven't done so already.
Good morning, our audience and our guest speakers. I'm very honored and proud to present a very dynamic person, a dedicated person with her goals and serving her country. She's been known to me over 30 years ago, and I am very glad that I'm part of her friends. I'm part of her friends. Her name is Justice Nottage. She's a fellow, Chartered Institute of Arbitrators, UK, a founding member of the CIArb Bahamas branch, and a former director of education training for the branch. She's currently a listed CIArb approved faculty member and an accredited CIArb mediation assessor and moderator. Justice Nottage lectures in constitutional and administrative law at the University of the Bahamas. Her specialty fields also include family law, alternate dispute resolution, and employment law. She has a very rich academic achievements, which includes Bachelor of Arts degree, honors political science and economics from Queen's University, Canada, Bachelor of Laws, LLB honors degree from King's College, University of London, Master of Laws degree, LLM, distinction in taxation and international economic law from University College, University of London, a Master of Business Administration MBA degree, Templeton Institute, Master of Arts, Schools and Theology degree from Oxford University, England, and a second Master of Laws, LLM distinction degree in canon law from Cardiff University, Wales. Justice Nottage is one of the 3 Bahamian appointees who sit on the World Bank's ICSID panel of conciliators and arbitrators. She has attended training courses in family and divorce mediation in Trinidad and Tobago. Wealth Management, BIFS Bahamas, and holds a postgraduate diploma in International Commercial Arbitration, Center for Commercial Law Studies, Queen's Mary, University of London, with a specialty in international trade and investment dispute settlement. She has played a very important role in drafting ADR legislation in our jurisdiction. Her vision of Bahamas, recognized worldwide for its talented and experienced pool of arbitrators, mediators, and conciliators, working both domestically and internationally. Her hope is that every Bahamian community will have persons trained in the basics of ADR. Her subject matter this morning is to cover the area of legislative framework. I present to you Justice Nottage.
Thank you so much for that very gracious introduction, former Magistrate Regan Johnson, and my true friend of 30 years. You're dating me.
We both are.
Honorable Chief Justice, Minister Johnson, my dear and honorable CIArb colleagues, ladies and gentlemen. For those of you who wonder why sometimes we call ourselves CIArb or CARB, we all refer to the short form of the Chartered Institute of Arbitrators in one or the other way. So you may find that I use CIArb interchangeably with CARB. In beginning to address you today on the framework legislation, particularly in arbitration, I'm very impressed, as Madam Kelvin Cunningham has said, with the Chief Justice's innovations and proposed changes. There truly is a paradigm shift that he is creating, and an earthquake change, as it were, in the arena of alternate dispute resolution, particularly mediation. And we will now look at the area of arbitration, where he too has also made tremendous inroads. I have a slide presentation. I would like that to be loaded now, if Madam Donath can do that for me. If not, I will continue talking.
It is loaded. It is loaded. Are you seeing the screen?
I'm probably not seeing the screen.
Okay.
Let me just see. Is anyone else, can anyone else say that they're seeing this? I am seeing.
The screen is on the left. You have to touch the slides as you go. Probably.
I'm trying to touch it. No. There it is. I have it. Thank you very much. And Donath, I think you probably can help me move it on, or if I can, then
well,
fine.
I will.
Thank you. We'll move forward then. Because in making this presentation on arbitration and overview, you're going to find that I will first talk about ADR. What is ADR? But first we'll ask, what is arbitration? And a definition that I found very, very helpful is that arbitration is often described as a form of alternate dispute resolution. So you see this word ADR keeps coming in, and we need to know what that means. Alternate dispute resolution in which parties agree to have their dispute resolved by a private third party decision maker, that is the arbitral tribunal, rather than through litigation in the public courts. So this is a choice that there can be taken by a complainant or an applicant not to go to court, but to choose one or other of what we call an alternate dispute resolution form or processes. The parties in these ADR processes, the applicants in these ADR processes, you will find have a number of choices as to which process they can begin with. But in arbitration, the parties agree in advance that the decision of the arbitral tribunal, that is the award that is finally given by the tribunal, will be binding on them rather than merely advisory. Now you'll find as I go on that arbitration produces a binding decision, mediation does not. So let's move on to the next slide. And I found it interesting that the CJ and I were thinking a lot along very similar lines as we prepared our papers, because I also looked to see where some of the roots of arbitration might have begun. And while he took us to the Greco empire of Plato, I'm going to take you to the Judeo-Christian book in which Solomon the Wise was an arbitrator. His adjudication occurred in the conflict between the two women as to whose baby there was. A baby had been born to two harlots, it is said in 1 Kings 3, and one of the babies had died overnight when the mother must have rolled over on it. So that particular mother went and took the live baby of the other mother and held it close to her. So a dispute arose as to whose baby this was. And Solomon was challenged. He became the arbitrator. And in his wisdom, after hearing the cases of both, he said, all right, I will divide the living child in two and give half to the one and half to the other. Now here you see exactly what the Chief Justice was speaking about when he said that ADR tends to move people a little away from focusing on their legal rights and towards considering their needs and interests. So Solomon exercised ADR. The interests of these two women, particularly the real mother. The real mother shouted out when she saw that sword rise to strike the baby. And she said, no, no, give the baby to her. That's all right. Solomon realized that his decision had been right, and he gave the baby to that mother who cried out because her interests, and the interests of the child, were put above the rights that the other one seemed to want to explore. But that's just very dramatic, all right? Let's also say that that was of old. We've moved on. Arbitration has moved on. In fact, now I'm going to be able to introduce you to what is a really interesting road mapping that the Bahamas is doing in the Bahamas International Commercial Arbitration, because we are hoping, as Minister Johnson has said, to road map an international commercial arbitration center. And among those proposals that you'll hear is one in which we will actually propose the appointment of the permanent court of arbitration, called the PCA, which sits in The Hague, Netherlands. We will be appointing an external court, as it were, as a part of our arbitration regime. We are becoming truly, if this occurs, if this legislation passes, we will be truly international, because we will be following some of the dictates or demands of the international community that local courts and international arbitration centers facilitate an immediate resource in arbitration for international differences. So international differences are becoming very important. And as has been said in one of the introductions, they are billion-dollar business, not just million-dollar. But arbitrations that are being made in international commercial arbitration often litigate or hear arbitration claims that start in the billions. May I have the next slide, please? As we move on, I would like to show you what I call the diagram of ADR. Now, this is also interesting, Chief Justice and others, because you'll see that here I am attempting to display what is called the ADR spectrum. Alternate disputes start with a dispute. At the left side of this frame, the best thing to stop a dispute is to prevent it. Well, we know that. That's very simple. And sometimes people prevent actual argument by just walking away. Now, that's one way of doing it, but sometimes that also leaves a very heavy heart and bitterness that the rights or the interests were not pursued. But we put that at the far left. As we move and the arrow moves towards the right-hand side of this frame, you'll see that aggrieved parties in any dispute can then move to negotiation. And this again involves the two parties. No third party is usually involved. It's a direct face-to-face negotiation between the parties in an attempt to resolve their dispute. But then, sometimes even in negotiation, we cannot arrive at a solution. So, whereas at the beginning of this diagram, the two parties are in control, we then see the arrow moving where they begin to release some of their control over the dispute to a third party. Then we have mediation. And mediation, as you have heard, is a neutral third party entering in order to assist the parties in arriving at a comfortable, reasonable, but mutual agreement. After mediation, we then move into something that can be called MedArb or ArbMed, which is a combination, as it were, of arbitration and mediation. It's a variation of the arbitration procedure in which an impartial and a neutral third party is authorized by the disputing parties to first mediate their dispute until such time as they reach an impasse. As part of the process, when the impasse is reached, the third party is then authorized by the parties to issue a binding opinion, an award on the cause of the impasse or the remaining issues. This can cause problems if they are the same person that heard the mediation, because often they have already been, as it were, heard a lot of the conflicting arguments, and they might be tainted or biased. So in some cases, MedArb uses two outside parties, one to mediate the dispute and another to arbitrate any remaining issues after the mediation process is completed. Now, this MedArb is very popular in the United States, but I'm not sure that that has been considered yet in the process that the Chief Justice has mentioned. We move on to the Ombudsman. I'm not going to stress that at this particular point, because that's usually a nationally appointed person, appointed by the government or officially appointed, who can look into arbitration or making decisions that are final with respect to public bodies, as it were. Then you can have a private mini trial. But notice this, as we move along this spectrum, this arbitration mediation spectrum, the parties are losing more and more control. They now are probably being represented by lawyers, and lawyers begin to use legal language. Legal language is not necessarily always understood or appreciated by the layman. So the lawyers have control of the project, and often the complainant sits quietly by, hoping that they have the right lawyer to do the right thing. We move along the spectrum, and sometimes one can have a judicial mini trial. And this happens where there may be retired judges or persons who are willing to allow the parties to voice their objections or their cases, and to get a sort of pre-trial or example as to where the fault may lie. A pre-trial arbitration conference is also possible, And then you have the ENE, of which the Chief Justice spoke, which is the early neutral evaluation. That's a matter that he feels that we really must explore. And I would agree with him. I think that as far as my research has taken me, this is an extremely important, as it were, half step between outright litigation before the court and mediation outside the courts. So early neutral evaluation uses a neutral third party to provide a non-binding evaluation, sometimes in writing, which gives the parties to the dispute an objective perspective on the strengths and weaknesses of their case. So you can see that again, you're probably dealing with lawyers representing the parties, but at least you're not yet at court level, where the rules are more stringent and the evidence is very strictly controlled as to whether it is clearly admissible or hearsay. That happens in court, but in all of these alternate dispute resolution processes, there is a relaxing of that sort of process. I'm going to leave that for the time being because I want to go on to the major part of my presentation. May I have the next slide? Because at the far end of this slide is, of course, adjudication, which is court hearing, where a judge takes final control. So what are some of the key features of arbitration? A, it is chosen by the parties. And so to that extent, it goes very much back to what I was saying about negotiation, that the parties are in control. The parties here in arbitration make up their own minds as to who they want to be their arbitrator. They also can decide where the arbitration is to take place. And they can even decide which rules they are, or this dispute is to be governed by. So the parties become extremely important in what we call party autonomy. B, the legal basis of arbitration rests on the parties' agreement. They usually have a prior arbitration agreement, which has stated that should a dispute arise, the matter will be taken and is agreed to be taken to arbitration. C, the parties dictate the law or rules to be applied by the arbitral tribunal. The parties choose the seat of the arbitration. The arbitral process may be confidential if the parties so wish. Often arbitrations are carried out very, very privately and may be taking place in a hotel conference room in which very important matters are being decided, but because it's all confidential, the press has no way of knowing what is going on. F, arbitral awards can be enforced in the same way as court judgments. This is an important aspect of arbitration, which I'll explore later, because if the country where the arbitration is taking place, that is the seat of the arbitration, is a signatory to the New York Convention, then the arbitration award can be enforced in any other country which is also a signatory to the New York Convention. Very convenient, and not as opposed to a court judgment, not as heavy as a court judgment, which will often not be easily enforced in another jurisdiction. And finally, in arbitration-friendly jurisdictions, and I'm glad that the Chief Justice said quite clearly that the Bahamas is an arbitration-friendly jurisdiction. In fact, it's becoming so arbitration-friendly that I feel that we're really well on our way to international arbitration. But in arbitration-friendly jurisdictions, the intervention of local courts serves mainly to facilitate arbitration rather than to regulate it. In other words, the courts in a jurisdiction such as the Bahamas is seeking to be, the courts are there to assist the arbitration and the arbitral tribunal and to facilitate that international aspect. rather than to try to regulate and prevent it. The next slide, please. Some major instances of arbitration, but we'll move on to an aspect of competence. The arbitral tribunal is said to be always competent to make its own decision. I think we'll stay with competence, please. We jumped one of the slides, but I think we need to move along. Under the doctrine, this is a doctrine that is known to arbitrators and known to international arbitration and domestic arbitration. The arbitral tribunal has the right to decide whether it has jurisdiction over the dispute brought to arbitration. Often what will happen whenever parties who have an arbitration agreement are called to arbitration, one party may say, I want the arbitration. The other party may say, no, I know I have an agreement, but as far as I'm concerned, I don't want this arbitration. I think there is nothing here and you don't have a claim. So the arbitral tribunal has the right to adjudicate on whether it has jurisdiction over the matter, which is a very court-centered right. I mean, it's something that normally domestic courts alone can do. But this competency of the arbitral tribunal is a commonplace in arbitration and one of the signature factors needed in international commercial arbitration. This is commonly referred to as the positive effect of competence, as it affirms the existence of a power on the part of the arbitral tribunal. However, in some jurisdictions, competence also produces what is called a negative effect. That is, sometimes the state courts lack the power to examine the validity of an arbitration agreement, even if requested to do so, unless it is on its face invalid. So just having known that particular rule of the arbitration tribunal, I'll move on to the next slide. And I think that we may have lost, or maybe I've lost the slide. I want to just mention investor-state arbitrations. These are a new type of arbitration involving states, and they have become quite prominent recently, particularly in international arbitration. So international arbitration, as the Chief Justice has said, has become an important tool, not only in ADR, but also a tool of economic development. I think that may have been said by Minister Johnson, and that is an important factor. Let's just go on to the road mapping of international commercial arbitration. You will find that now the Bahamas has proposed a 2018 legislative framework where they will, as it were, incorporate the model law, the UNCITRAL model law, and that would make our arbitration, International Commercial Arbitration Act, UNCITRAL model law compliant, which is important because the international community will then realize that we are competent to hear and to allow the hearing of international commercial arbitrations in our jurisdiction, that we respect them and will respect the internationality of their existence. I go on to say that international commercial arbitration, in the next slide, is permitted under the UNCITRAL model law and usually applies, and this is very fine type as well. An international arbitration is usually one in which the parties have their place of business in different states, or one of the following places are situated in a state in which the party has their place of business. There's an international aspect in that the parties are not all from the same state, and their seat, that is where they're actually hearing the arbitration, may not also be the place of business of either of the parties. And so once that has been established, then the arbitration is deemed an international arbitration, and particularly an international commercial arbitration, which then will be regulated by our proposed new legislation, which has been called the International Commercial Arbitration Act of 2018. Now, in that act, there will be a new event occurring, in that not only will the courts of the Bahamas have jurisdiction over certain matters, but if this bill is passed, we will also join a very elite group of international jurisdictions in which the Permanent Court of Arbitration, this is a court that was founded in the 1800s as the peace court for the entire United Nations community. That court will become an appointing court for our international commercial arbitration matters. Now that will mean that the persons who sit in arbitration here in the Bahamas as its seat will be comforted or will be assured that certain of their matters, as set out in the bill, are able to be decided, and they're usually procedural matters. They will be able to appoint the PCA to make those decisions. That's very profitable for us, because sometimes these arbitrators or parties may have historical aspects to them. They may be well known in Portugal or well known in Hong Kong for certain work, whether nefarious or not, which they have done, but we in the Bahamas may not have that knowledge. Whereas an international arbitration court, the PCA, would certainly have access to that, because they would have appeared before either the PCA or similar courts. So that presence of the PCA as an appointing authority brings an added assurance to those who seek to perform international commercial arbitration here in the Bahamas. So we move to the last two slides. I'd like to just say that the Bahamas and the proposed amendments that Minister Johnson has mentioned, together with the fact that we are a model and will be a model law country which has signed on to the New York Convention, those two bills and the amendments thereof, because there will also be an amended Bahamas Domestic Arbitration Act, those two bills will sit us in good stead for being a center for international commercial arbitration. My final slide is the future remains arbitration. That is the future, not just for the Bahamas, but the future for this post-COVID world. Arbitration is now the principal method of resolving international disputes involving states, involving individuals, and involving corporations. This is one of the consequences of the increased globalization of world trade and investments. And it has resulted in increasingly harmonized arbitration practices, which we hope to have in our own international commercial arbitration statutes. Specialized international arbitration practitioners will be attracted to our shores, and we ourselves will become very familiar with this. And in that way, the Bahamas will be the center that is much sought after. Thank you. I think that's enough of me. And thank you, Donette. I've had enough of your time. Thank you for allowing me this time.
Thank you so much, Justice, Retired Justice Nottage. You did a great job. And so I'll hand over back to my moderator, who I'm trying to find on the line.
I'm right here. I'm right here. Yes, thank you so much, retired Justice Mrs. Ruby Nottage. As always, you have so much information and so much knowledge. We are very grateful. Our second panelist is, our presenter is a dedicated member of CIArb Bahamas branch from its birth in 2010, qualified trained mediator and arbitrator, senior partner in the law firm of Dupuche and Tonkes, advocator of relationship matters. She is one of the leading members of the Legislative Committee of ADR. Her topic is going to be building an ADR practice. ADR is the best option. Mrs. Carl Lashley is a barrister of more than 40 years. In fact, I know her about that time. I met her, I think, first time when we were at the Inns of Court. I was a little student attending my dinings requisite by the Lincoln's Inn. And she's a standing with experience in litigation, family, corporate employment, and trust matters. She's a fellow of the Chartered Institute of Arbitrators. She's proficient both as an arbitrator and a mediator. Her professional membership includes International Federation of Women Lawyers, the Society of Trust and Estate Practitioners, Mediators Beyond Borders, International Mediator Academy, International Bar Association, Bahamas Bar Association, where she served as a secretary from 1992 to 1995, and as a chairperson of Ethics Committee from 2000 to 2017. She's currently the chairperson of the ADR Committee of the Bahamas Bar Association. She has been a fellow of the Chartered Institute of Arbitrators since 2012. And in 2014, she obtained an advanced certificate in trust and estate mediation from STEP. She has been designated by the Bahamas government to serve on the panel of arbitrators and conciliators. Mrs. Lashley was selected to participate in ICSID's first mediation training in June 2017 at the World Bank in Washington, D.C. Most recently, she undertook train-the-trainer mediation training with Ken Clark in April 2018. And similar training is offered by the Chartered Institute of Arbitrators earlier this year. It gives me great pleasure to again introduce a very, very informed, excellent arbitrator and mediator. Thank you.
Thank you very much, Rangan. CJ, Minister, greetings. Now, my topic, I'm not even sure how I start here, but I believe that you have to firmly believe that ADR is the best option to be successful at and with the ADR processes and to establish a practice. What does a successful practice mean or look like? Wealth, fame, great achievement, so many questions. I will start by determining that ADR is indeed the best option. To this end, we all have to do some introspection and decide that we will enable those in the process to have a very important role in the process. It cannot be about us. We have to be open to change. We have to be sufficiently courageous to examine what led the disputants to the position they have arrived at. We have to look at the emotions they express and give both legitimacy and value to them. For those of us engaged in the practice of law, many of us already have a mindset fixed on winning. In ADR, our mindset must be focused on resolution rather than on winning. That change of mindset is not an overnight process. A part of that process is to encourage our clients not to take matters to court. We have to encourage them to seek resolution. And using the CJ's words, we have to encourage them to embrace diplomacy and not to wage war. No matter what our profession might be, education of our clients and education of the public on ADR must be a part of the equation. We have to have an educated public in order to have clients in an ADR practice. The courts have a part to play in all aspects of the resolution of business and family disputes. That is the traditional concept. In our jurisdiction, where the court has many matters backlogged, and where the process is used and abused, primarily by attorneys, many people consider success as synonymous with winning, whether winning financially, socially, or howsoever, but just winning. ADR is not about winning. As the CJ said earlier, it's about getting and being a better process for the resolution of disputes, determining what is fair in the circumstances which are before us. In many instances, it is simply about relationships. Relationships matter. What does a successful ADR practice look like? Even today, although I engage somewhat in arbitration and mediation, I have not ceased my mainstream legal practice. I have, however, changed the way that I practice. I spend quite a bit of an effort ensuring that my clients all have an ADR clause in any contract I assist with. And that is across the board. I spend much time on the education of those who might be or who might know potential clients. A successful practice is a journey which requires determination, patience, perseverance, persistence, and courage. A successful practice requires us to take advantage of every opportunity, trying to assist with reducing the impact of adversity while retaining and maintaining a position of integrity. Anything that's worth doing is worth doing well. We all grew up hearing that. I knew immediately I embarked on the ADR road that I could not leave or diminish my efforts in my day job. To make inroads in an ADR practice, I had to put in a great deal of time, many, many resources, and vigorous efforts. That is the reality. So what comes first, the chicken or the egg? Do we wait for everyone to know about ADR and for people to become knowledgeable about the process before we embark upon the ADR education process? Or do we educate ourselves and be as prepared as practitioners as we can so that when the clients are ready for practitioners, we as practitioners are available to be engaged? In our jurisdiction, even today, there are many who do not have a clue about ADR. So the constant has to be a campaign of awareness and education. And for those who do know about ADR, the challenge is to commit to change, to venture into uncharted waters. I was not concerned about my ability. Most people who decide to venture into this field of endeavor have ability. Most of us are already in the work environment in some profession or the other. The question then becomes, how do I start? We, either ourselves or our parents, have already spent a mint of money on our education in our current profession. So now there's no money to do this. Education costs. To do something well, we have to be trained. We have to make the sacrifice. Otherwise, we venture out into a new arena, a new field, without any expertise, without sufficient knowledge, and we shoot ourselves in the foot because we demonstrate that not only do we not know what we're doing, but we kill our reputation before we get off the ground. I spoke about integrity earlier. We also have to make sure that we do not abuse the process. We have to make sure too that one or other of the parties is not allowed to abuse the process. The integrity of the process must be more important than our hourly fees. In a mediation and in an arbitration to a lesser extent, attempted manipulation of the process indicates a lack of good faith and a lack of courage. It demonstrates fear and a lack of confidence. It is important when setting the stage to speak to topics such as bullying and the tactics that have the tendency to derail the process. Those tactics usually come about where there is an inequality of bargaining power or some perceived bravado which has to be maintained. We have to have the courage to acknowledge our limitations. We have to have the courage to acknowledge when we are wrong. We have to know what we do not know. Luckily, information, knowledge, learning, and wisdom, they're all out there. They are at our fingertips, and we do not have to travel to get them, but we have to pay to get them. Most of it is not free. I pray always for the strength and wisdom to recognize what I do not know and to consistently work hard, keep reading, continue to study and profit and grow, not only from my personal experiences, but also from the experience and wisdom of others. That's success. Thank you.
Thank you. Our third panelist, her name is Kenya Notich. She's a barrister. She's a member of the Bahamas Chartered Institute of Arbitrators. And her topic is going to be on maritime arbitration and mediation. Ms. Kenya Notich.
Thank you, Madam Moderator. I hope everyone can hear me. Protocol having been established. You can definitely tell that we are amongst some very distinguished persons. CJ and Minister, it is good to see you and thank you so much for coming. I have been urged to ensure that my presentation is as concise as possible, so I will definitely ensure that I do that. CJ and definitely Justice Notich, I thank you very much for making my job very, very easy, because both of you have wonderfully defined arbitration and mediation, so I really don't need to go into any of that. I will literally now focus on the maritime element, which I'm absolutely passionate about. The area of transport and transportation has been a unique passion of mine for quite some time. But highlighting, first of all, for those of you who may not be familiar with maritime, just to briefly give you a definition of maritime, which is an analysis of matters connected with the sea, our oceans, our waters. The second part is to highlight and look at maritime from the perspective of our legislation. As a jurisdiction, even though we are a small jurisdiction, we have a mighty bundle of legislation that we often deal with simply because we have not only just ship registry, but we're involved in so many other areas of shipping, which I will broker into in a couple of minutes. So for example, we have the Merchant Shipping Act, which is directly connected with our Bahamas Maritime Authority, the Commercial Recreation and Watercraft Act, which many of you know is connected with our jet skis industry. Those of you who don't know, there's a ensure conscious ruling and display of the development of our jet ski industry as a tourism industry, and to ensure that all visitors are safe when they engage in that area and any other type of water sports. The Boat Registration Act for boats, including the mail boats that may traverse within our waters. And of course, the Port Authorities Act, which is very interesting because of course, we're currently developing our port. We also have one of the few jurisdictions, our jurisdiction is one of the few jurisdictions that actually has a committee that creates policy, maritime policy, which is also very exciting. And that's known as the National Maritime Policy Implementation Committee, which is dedicated to creating the policy that it sees where a maritime area is developing, but no law exists, but something must be addressed. And so for business efficacy and to ensure that there is something there in place for the Bahamas to address, we have the committee there that works very, very hard, tries to meet, I think about, well, it's been once every 2 weeks, and it's been very, very good. I see 1 or 2 committee members amongst our guests here. I'd also like to highlight that maritime has a very wide reach. So, you know, I've mentioned domestic legislation, but I would also like to mention the regional legislation, which is the CIArb Revised Treaty of Chaguaramas, 2002. And Section 6 deals with the transport policy. So regionally, the Bahamas also has a commitment to its maritime endeavors. And I just want to show you a brief copy. It's a very sort of well-eared book of my treaty. This is the CIArb Treaty of the Revised Treaty of Chaguaramas. And then taking it up a level, internationally, you have the United Nations Convention on the Law of the Sea, of which I have a book before me as well. And this endeavors to regulate our oceans from an international level. And I have the honor, the distinct honor of representing the Bahamas at the International Maritime Organization as its legal representative. And of course, UNCLOS is addressed wholly and completely and consistently. I also want to pique your interest in terms of the maritime industry in the development, not only of employment, but perhaps areas that may be arbitrated within the dispute resolution aspect. So for example, you have ship construction. How are ships going to be constructed in this COVID-19 environment? Are we going to wholly rely on vaccines? Or are ships going to be specially purposed to ensure that visitors or guests are safe in their travel? The registration of ships, which many of us know through our Bahamas Maritime Authority. Ship marine and insurance, very, very important, particularly, and I will mention 2 words, if we consider oil spills, if we consider spillage from our ships in any way, which is known as ballast water and ship discharge. What happens in those cases? Also ship manning, which includes crews and the treatment of crews. The Marine Labor Convention addresses crew issues, but also employment issues and ship management issues. Ship brokerage. You may be a person who is a broker who may, for example, not necessarily own a ship, but ensure that a ship is sold to another person. And that's just one aspect of ship brokerage. And of course, port safety, port management, port security, all very important, and never forgetting marine environmental matters. My next very brief topic, areas of interest which directly involve our jurisdiction, which are very interesting, which are very topical matters within the Bahamas. So for example, I'm sure many of you have heard, and if not, particularly for those who are guests here within our panel, there have been various incidents of overfishing by foreign nationals within our jurisdiction. There is an incoming vessel as we speak that has the intent of ensuring that there will be the drilling of oil within our jurisdiction. How do we approach that? Very interesting. The issue of crew changes and crew abandonment in our COVID-19 circumstances. That should be interesting. And of course, many of you know that here in the Bahamas, our port is expanding and developing in many very interesting ways. How will that affect our seas? So in covering all of that, I will simply end by saying and reminding all of you that the Bahamas, by definition, very loosely, is known as the land of the shallow seas. It is a core component of who we are and our culture as a people. And I think we ought to remember that. We ought to ensure that when we are addressing the maritime industry, it is an industry to be developed, to be protected, to be promoted, and to be progressed. Well, I hope I've given you a very brief overview of this area. I welcome any questions, perhaps even after. But I thank you all very much for your kind attention. Madam Moderator, I hand it back over to you. Thank you all.
Thank you so much. Wonderful presentation. Our fourth panelist, Ms. Dominique Nottage, is an attorney at law. She is a member of the Bahamas CIArb. She serves as its chair of the Young Arbitrators. She's a remarkable young lady. I'm very pleased to present Dominique Nottage. Her presentation will be on career opportunities in alternative dispute resolution. Ms. Nottage?
Good afternoon, everyone. Can you see my screen for the PowerPoint?
Not yet. Let me help you out.
Okay.
There you go.
Thanks. Can you go to the first slide, please? Thank you. So good afternoon again, everyone. I won't take that much time. It's just a quick run through of what we consider the careers in ADR. And some of my presentation would have been, would overlap with that of Mrs. Lashley on how to build an ADR practice. So we know that there are several options within this practice area of which you can do. So you can be appointed as an arbitrator, as arbitration counsel, as a tribunal secretary, or you can act as a mediator, or in instances of construction adjudication, the person who would adjudicate that dispute. So we know that those are the areas or typical areas that have room for growth in ADR. But I wanted to focus my presentation more so on what to do to get those roles, especially in the Bahamas, which we consider to be an emerging jurisdiction in ADR and does not necessarily have the same opportunities as those who may be based in London or Geneva or Hong Kong or Singapore. So with the next slide, Donna, please. My first thing is you have to recognize that you have to have time to put into this. For me, a lot of persons see me as a junior counsel, and with the role I'm in now with the ministry as an arbitration consultant, and think that, you know, it's been a short span of time for me to get to this position. But in reality, I've been working towards this since I was a first-year law student in 2010. So there's been 10 years of work to get to this position. And for me, this is only a starting point to the next set of goals. So you have to have a lot of time to invest in your career as an ADR practitioner. And it's something that doesn't happen overnight. And you have to do it outside of your professional day-to-day activities, because most of the time you don't have the opportunity to practice ADR 24/7. As Mrs. Lashley would have indicated, she still had to focus on her day-to-day practice. And it's not something that you can let go of and just focus on ADR, especially in the Bahamas. So besides the investment of time that is required, it also requires a very big commitment. It's not something that you can easily let go of, and it's hard to stay motivated, especially when you don't have as many opportunities as your counterparts in other jurisdictions. So you have to be committed in terms of your time. You have to have a personal commitment, and you also have to have a professional commitment to it. And it involves a lot of additional training, which comes at a cost. It's not cheap to become trained in ADR, and you have to therefore invest your money as well in developing your ADR practice. So in terms of creating your own opportunities, I think it's important to build your professional brand, to use networking to your advantage, to publish and to use alerts. When I say use alerts, for me, I set Google alerts, and keywords I use are international arbitration, international commercial arbitration, arbitration in the Bahamas, etc. And every day I get several alerts related to those keywords about articles that are on the internet, either whether they're in relation to what's going on in the Bahamas or what's going on worldwide. It's a way of helping you to keep abreast of what's going on in the community and keep aware of cases that have come out, like, for example, the Enka and Chubb case by the UK Supreme Court that talks about arbitration agreement, and the Vodafone case that talks about India and the biggest investment award. So it's important to keep abreast of what's going on in the community in order to create the opportunities necessary for you to become an ADR practitioner. So we keep on hearing, Mr. Diggis said it, Minister Johnson said it, Mrs. Lashley said it, that with every challenge comes an opportunity. So right now with the COVID-19 pandemic, I think we have a unique opportunity to expand our networking. You don't have to travel to go to conferences anymore. Most persons are, sorry, my apologies. Most persons are using webinars to connect and using the opportunity to have virtual coffees with different practitioners across jurisdictions. And I think that is worthwhile because you have to know persons within the international arbitration community in order to have access to those career options. Nobody can appoint you as an arbitration counsel or as an arbitrator if they don't know who you are. And directly related to that is the networking aspect. Independent of those webinars, you can also join professional organizations like Young ICA itself, the International Council for Commercial Arbitration, CIArb, which has a Bahamas branch and which is planning to do more activities to support membership, and the London Court of International Arbitration, Bahamas Bar Association, etc. There are organizations that are geared towards attorneys and also organizations that are geared towards professionals. I want to emphasize that to become an ADR practitioner, you don't always have to be an attorney. It's really open for everybody. Our ex-com chairman, he's an architect by profession and he's involved in the industry. Nicolette is a treasurer. She's a accountant by profession and she's involved as an ADR practitioner. So it's not limited to attorneys. It just happens to be that mostly attorneys are involved at the forefront of the industry. So in terms of networking, we talked about relationship currency and why that matters. So relationship currency is generated by the investments you make in the people in your environment. And for me, I have been able to connect with a lot of different persons based on the relationships I've had with them, and those persons have been able to provide me with opportunities that I may not have otherwise had. And I think it's important that you not only focus on networking with persons in those professional organizations, but also with developing valuable relationships with those persons. And once you build true relationship currency, it will motivate people to act on your behalf or connect you with other relationships. And my final top tips, just to close out the session. So this is kind of an in-between between career opportunities and ADR and how to build your ADR practice. I would say that you can find out what form of ADR you're most comfortable with, and you can constantly educate yourself on that form of ADR. We have persons in CIArb who focus on arbitration and mediation, and some people who just focus on construction adjudication. It's really up to you to what you connect with mostly and what you feel that you can really make a difference in that area with. I would advise you to, notwithstanding the fact that you may have a specific area that you are more interested in, to be sure to learn all of the basic forms of ADR. And specifically for attorneys, to learn how to draft ADR clauses. I think that's one of the key ways you can create ADR work for yourself, is by encouraging your clients to use ADR as opposed to litigation. And you do that by knowing how to draft a good arbitral clause that's not pathological. And then that would move towards arbitration or mediation processes as opposed to going straight to court. I find that attorneys sometimes run away from ADR clauses and just go straight to court. Just this week, I was approached by a colleague who had taken over a matter for a client that had already filed a writ by the previous attorney, even though the contract between the parties had an ADR clause, and that's quite common. So once you learn the value of an ADR clause and how to draft that, that's another way for you to start your career, because you are the one who's promoting, the one who would be controlling your opportunity in it. Again, I mentioned professional organizations. So they all have publications. CIArb has the Evolver. They all publish very good articles, and you can always reach out to those organizations and reach out to their respective publications to become published or find out how you can become published, because that's another way to build your professional brand, get your name out there, and create a career opportunity for yourself, for someone to reach out and say, hey, this person is in the Bahamas. They know about arbitration. I need arbitration counsel who is familiar with the Bahamian law, and I'd like to appoint them. So I also, as my final tip, advise you to be aware of the major changes in the international arbitration community, not only the cases, not only the topic areas that are hot topics like third-party funding, but also to keep aware of who's legal, which firms are listed on Global Arbitration Review, and to know who your colleagues are in the region, in the world, and to know the type of work you want to do in this space. And all of those things that I mentioned would contribute to creating a career for yourself in ADR. I'm free to ask any questions after the webinar by email. I will drop my email contact in the chat just in the interest of time. So thank you.
Thank you. Thank you, Ms. Norwich. It was an excellent presentation. Our last panelist, fifth panelist, is Mrs. Cherise Brown. She's a member of CIArb and the Bahamas branch educational chair. She's an attorney at law, and she's the CEO and the senior legal counsel of the Grand Bahama Development Company, known as DEVCO. Her subject matter this morning is to be giving a presentation on training opportunities, path to membership and beyond. Ms. Brown.
Thank you again. Thank you so much. I'm going to rest and rely very heavily on established protocol and just say good afternoon to everyone. There are 4 things in the interest of time that I want to emphasize by way of training. The first is, now is the time to engage in training. Carpe diem. We are going to be required to support by way of providing arbitrators, mediators, faculty, administrators for the proposed commercial arbitration center. In addition, you've heard about the changes to the CPR. And again, we need to be able to be in a position to provide support to these institutions. Our training is virtual, and over the last months, we all know the convenience of virtual training. And because it is virtual, it will be less expensive. So we again encourage and invite you to take the opportunity to begin your training if you have not done so. As Monique indicated, there is absolutely no need to have any prior legal training to undertake our courses. The cohort that just completed the International Arbitration course, the final module, was made up of an architect, doctor, engineer. You don't have to have legal training. Whatever legal principles you need to get an understanding on would be provided in the courses. Ours is a very big tent. We are inclusive. I see we have educators on the call. We also have HR professionals on the call. You are more than welcome to to participate in our courses. 3, the CIArb administered courses are administered by approved faculty. And we are so pleased, as our chairman indicated earlier this morning, that we have approved faculty in the Bahamas who can run our courses. The training is also courses approved by CIArb. And so there's a level of certainty there because they are approved by CIArb, and the quality is also maintained. Our pathways to training, and these are just pathways, are a guideline that you can use for training. There are 3 modules in each subject. Each module is also tied to a link or linked to a membership level in CIArb. For example, international arbitration. The first module is procedure and practice. Once you have completed that first module and you've passed your assessment, you are eligible to become a member of CIArb, and you're at the member level. Once you've moved on to the second and third modules, the second module deals with the law of obligations, which is contract and tort law. Once you've completed the second module and the third module, which is a substantive law relating to international arbitration, you would be eligible to become a fellow of CIArb, a fellow member of CIArb. In addition, you would also have to complete a peer review session. So the modules are linked to the membership level in CIArb. So that's something I want you to be aware of. Those are the 4 things that I wanted to emphasize and to share with you today. Finally, I also want you to save the date. We're going to go back to basics, and we're going to start with introductory courses in arbitration, international arbitration that is, in mediation and construction adjudication. And those courses will run from February 4th, 2021 to February 10th, February 2021. We have Justice Nottage, who will be leading the course on international arbitration, Introduction to International Arbitration. And we have Ms. Carol Lashley, who will be leading the course on Introduction to Mediation, both eminently qualified. We will be obtaining a CIArb-appointed faculty to lead the course on Introduction to Construction Adjudication. So I just want you to bear those dates in mind. We'll put the save the date in the chat. And I also just want to thank you. And for those of you who have stayed on the call, we've run somewhat over time. We have a little trivia for you. Anyone who is on XCOM or who is a member of CIArb, I'm sorry, you are not eligible to participate. So, and I would like you, if you can, just type the response in the chat. I'm going to ask Doneth and Monique if they could monitor the chat for me, please. And the first person to answer correctly, we will gift you with a $35 gift certificate to Kelly's. So the question is, what is the slogan or motto for CIArb? What is the slogan or motto for CIArb? There you go. Adriana, you are a winner, Evolving to Resolve. So please get us your contact and we'll make sure you get that gift certificate. Thank you very much for your attention. Over to you, Rangan.
Thank you. Thank you, Cherise. Excellent presentation. And I like that little gift idea with a question. I would like to complete as follows. The purpose of this webinar is to introduce the CIArb Bahamas branch, to present its objectives to our audience, and to give information on its courses and goals. And I think we have, in my humble opinion, have definitely done our best to do that. I would like to add the following, and this is probably have not been so far touched. I believe that we are in the right place at the right time to have the arbitration center. The legislations being proposed and prepared, and we are following the model law. And we also have the market to conduct our ADR courses, and also to have clients, both locally as well as from globally, to use our center as a place to have their proceedings. Bahamas is a leading maritime jurisdiction in which vessels from all over the world are registered. Since 1997, Freeport Container Port, DevCo, located in the island of Grand Bahama, is one of the largest ports in this hemisphere. We are only 65 miles from Florida. The port offers many services, shipping lines, handles largest container vessels in the world. It conducts repairs, refurbishing of vessels. Freeport and Nassau are also amongst the top destinations for cruise ships. It is expected that in order to facilitate the growing maritime industry, ADR legislation will be required for arbitration and mediation in maritime disputes. So therefore, we definitely need our arbitration center, ladies and gentlemen. The popularity of the alternative dispute resolution is escalating in both private and public sector. ADR is used in many types of disputes: treaties, domestic matters, patents, trademarks, patents, sports, artist promotion disputes, banking software, trade unions, employment matters, construction, maritime, etc. The list is limitless, other than criminal matters, and also persons who wishes to have their divorce. Unfortunately, so far, we will not be involved with that. Since COVID-19, ADR has become more popular through Zoom online arbitration and mediation and negotiations proceedings. Further, each institution requires a very organized administration team. And we have such qualified persons. We need experienced trainers, and we have such persons. ADR coordinators, etc., are the future of our ADR program. CIArb England and CIArb Bahamas branch have online courses, as very well explained by my colleague, Cherise Brown. For further inquiries, I'm encouraging you to contact education and training support of CIArb England and CIArb branch. It is also recommended, ladies and gentlemen, that you visit the websites of both England CIArb as well as the Bahamas CIArb branch. CIArb supports more than 16,000 ADR practitioners, and it is spread out through 149 countries. I think the message is very clear, as it is so stated by some of my colleagues. ADR is the future, and we are going to be the future, the best arbitration center for the Commonwealth of the Bahamas. I thank each and every one of you, our audience. I hope that you've learned more about us, and if you need to contact us, we will be more than glad to serve your interests as well as your inquiries. With that, I pass on the program to our host, Ms. Cartwright. Thank you so much.
Thank you so much, Rengen. You did an awesome job as moderator. The most important asset you have is your time. And we are indeed grateful that you spent the last almost 3 hours with us. We will not take that for granted. But to say thanks, I will call on ExCom member Nicolette to do the vote of thanks. Nicolette?
Good afternoon, all. What a great time to be involved in alternative dispute resolution and to consider becoming an arbitrator or a mediator. First, I wish to thank all of you for carving out time on this beautiful Saturday in December to meet with us today. I know most of you want to get on with your Christmas shopping. But some great news. You have already received your first star in ADR. Thanks to our guest speakers, Minister Ellsworth Johnson and Chief Justice Sir Brian Moree QC, for taking time out of their busy schedules to join us today and to share their vision for the future of ADR in the Bahamas. We at CIArb Bahamas are very grateful for their continued support. A special thanks to Mistress Donette Cartwright, our host, and the brains and bronze behind our official inaugural CIArb Bahamas branch ADR webinar. We are grateful for all of her hard work and commend her for an excellent job, which was well done. Also, thanks goes out to Mrs. Regnan Johnson, our moderator, and our esteemed panelists, Justice Ruby Nottage, Ms. Theo Monique Nottage, Ms. Sharice Brown, Mistress Carol Lashley, and Ms. Kenya Nottage, for enlightening us on all aspects of ADR in the Bahamas, from legislation to becoming a qualified arbitrator or mediator, and possibly building your own ADR practice. And last but not least, special thanks to our chairman, Mr. Michael Diggis, and to Mistress Shellen Ingram, Ms. Yolanda Roll, and Mistress Kelvin Cunningham for their help and support in organizing and producing this successful webinar today. Wishing you all happy holidays and a Merry Christmas from CIArb Bahamas branch. Thank you.
And that, my friends, it's a wrap. We're now at the end of our webinar. We thank you for investing 3 hours of your Saturday with us. We ask that you go about safely, have a wonderful weekend, stay COVID-free, and have a wonderful rest of your day. Thank you.
Thank you.
Thank you. Thank you. Wonderful event.
Yes.
Thank you.
Goodbye, everyone.
Bye.
Thank you.
Thank you very much. Goodbye and thank you.
Bye-bye.